Legal Talk on eRadio with Hahn Hahn Attorneys, and today we're joined by Isabella Mazzone. The question that we're asking is, I purchased a vehicle from a dealer and I found it is defective. What can I do? This, of course, being a second-hand vehicle. There's a lot of scamming going on nowadays. I mean, it's easier than ever to get a second-hand car. You know, it's just a click of a button nowadays. Isabella, a big hello to you and welcome once again to Legal Talk.
Hello, Ian. Oh, it's so nice to be here and to have this conversation with you. How are you?
I'm great, thank you, Isabella. And how are you?
I'm fine, thank you. Very well.
So, you purchased a car now from a second-hand dealer and you found it is defective. What can you do? I mean, we've got the Consumer Protection Act protecting us from all these things, these terrible things. When does the Consumer Protection Act, or we'll call it CPA, apply to my case?
So, I think at this stage it's important to just note what the CPA defines as a defect. So in Section 53 of the CPA, they define a defect as any material imperfection in the manufacture of the goods that renders the goods less acceptable than persons generally would be reasonably entitled to expect, or any characteristic of the goods that renders the goods less useful, practicable, or safe. So those two aspects of what you would be reasonably entitled to expect and what is actually useful, practicable, and safe is what's important when defining a defect and when looking at your vehicle and what you can see is actually defective. Now, a very important right that the CPA actually affords all consumers is the right to safe, good quality goods. And this can be found in Section 55 of the CPA. And there are 4 components which are important when it comes to receiving goods, and that is that they are reasonably suitable for the purposes for which they are intended, that they are of good quality and in good working order and free of any defects, that they will be usable and durable for a reasonable period of time, and that they comply with any standards or public regulation. This section actually also states that when looking at the above issues, if a consumer has specifically informed a supplier, which would be the dealer, the purpose for which he's actually buying the goods or the use to which he intends to use those goods, the consumer has the right to expect those goods in a reasonably suitable order for that specific purpose. To determine this, the circumstances of the supply of those goods must be considered. This is not limited to the manner and purposes for which the goods were marketed, the range of things that might reasonably be anticipated to be done to those goods, and the time when the goods were actually supplied. So the Section 55 is quite a long section, to be honest, but it's important also to realize that it is irrelevant whether the product failure or defect was latent or patent, or whether it could have been detected by a consumer before taking delivery of the goods. The product failure or defect may not be inferred in respect of particular goods solely on the grounds that better goods could have become available as well. Section 56 is actually where that right to safe, good quality goods comes into action, as it specifically deals with implied warranty of quality. This section is actually what a consumer must read and read well, because this is really where your rights are important and you can realize those rights through specific alternative dispute resolution. So Section 56 states that each supplier of goods there's an implied provision that the producer or importer or distributor or retailer, so the dealer would fall under either one of these, they have to warrant that the goods comply with the requirements in Section 55, which is the requirements I just stipulated. So each supplier has to warrant this quality of goods. Within 6 months after the delivery of any goods, the consumer may return those goods to the supplier without penalty and at the supplier's risk and expense if the goods fail to satisfy those requirements. The supplier must, at the direction of the consumer, then either replace or repair the defective goods or refund the consumer for the price paid. If a supplier repairs any goods within 3 months and then that repair has not been remedied, or there's a further failure or defect after the repair, the supplier must replace the goods or refund the consumer the price paid. So this is all clearly stipulated in Section 56. The implied warranty and the right to return are also in addition to other warranties that might have affected the goods, normal warranties that would be included in any kind of agreement. So it's a completely additional warranty that the CPA affords a consumer. The timelines in Section 56 are very important. So it's the 6 month and the 3 month. And this will assist you in determining whether the CPA actually does apply to you. What's also important to note is that the CPA will only apply if the seller is acting in the course and scope of his or her business. The CPA specifically defines that a transaction means when a person is acting in their ordinary course of business. If the seller of the vehicle is selling it as a once-off sort of a thing, just reselling their car to you, then the CPA unfortunately doesn't apply because it would not be their normal course of business. However, obviously, most vehicle dealerships and secondhand vehicle salesmen conduct these sales in their own ordinary course, and then therefore the CPA will apply.
Okay, Isabella, well, that's very, very interesting. I've just been sitting here listening and taking it all in. Let's move on to the next one. What legal remedies under the CPA are available to me?
So there's normally 3 reasons why people seek these remedies, and that's for breach of the CPA, fraudulent misrepresentation, or breach of the actual sale agreement. So if you bought a vehicle and it's defective and doesn't comply with the requirements of Section 55, then they're in breach of the provisions of the CPA. In this case, you may return the vehicle to your supplier, to the dealership, without penalty within 6 months after the delivery of the vehicle. So after the vehicle is actually picked up from the dealership, you may go and ask for a complete, whatever you require, if you want repair, if you want replace, or if you want refund. So those 3 remedies are available to you under the CPA. But it's really important to consider whether the vehicle you have was used after you became aware of the defect. So that time lapse between you becoming aware of the defect and returning it to the dealer or informing them that they need to repair it or refund you, it may result in the dealer not providing you with a full refund. But this is actually dealt with on a case-by-case basis and will really depend on the facts. The CPA also does not apply if the goods were altered or tampered with by the consumer after delivery. So it's really important that you don't try and repair the vehicle yourself. When it comes to fraudulent misrepresentation, that's when the seller was actually aware of the defect before they sold you the car. They didn't disclose it to you, and you bought the car. So now they are liable for fraudulent misrepresentation. You, as the purchaser, will then need to prove that this defect was there at the time of the conclusion of the contract of sale, so when you picked up the car, and that the seller actually deliberately concealed it from you. If you can prove this, you can actually claim monetary damages, cancel the sale and claim repayment of the purchase price, or claim a price reduction. Now, this isn't only under the CPA. This can also be available to you if it doesn't fall under the CPA. Lastly, with the breach of sale, that would be where the actual agreement sets out specific warranties made by the seller, such as this vehicle is free of any defects and have not been in any accidents. If it has that and you later find out that there have been indeed these defects or the vehicle was in an accident, you can also claim a breach of the agreement. But as I said before, this would also be something that is not only under the ambit of the CPA. You could apply for this separately.
Okay, and Isabella, I'm just wondering, can I also go directly to court or not?
So this is interesting because when it comes to a transaction where the CPA applies, you're only allowed to approach a normal court if all the avenues of redress, which are actually in Section 69 and Section 70 of the CPA, have been exhausted. Now, in South African law, where there's a specialized framework that's been created by the legislation for a resolution of disputes, parties must, as a general principle, pursue claims through such frameworks. So these mechanisms are available to a consumer, and they're available in terms of Section 69, including the following. So there's the applicable ombud or industry ombud, accredited in terms of Section 82.6, which would, in this case, would be the Motor Industry Ombudsman, MIOSA. There's the National Consumer Commission, the NCC, the National Consumer Tribunal, the NCT, as well as a consumer court, which there are consumer courts in each province, so it's a provincial court. If you approach the dealer and he or she refuses to act in accordance with the CPA by repairing the vehicle or refunding you, the very first step would be that you'll need to submit a complaint against the dealer at the Motor Vehicle Ombudsman, MIOSA. This is a free service available to all South African consumers. If you are not satisfied by the outcome from MIOSA, you'll need to lodge an appeal with the NCC. And thereafter, if you are still not satisfied, or alternatively, if you get given a notice of non-referral from the NCC, you may then submit an application with the National Consumer Tribunal, which ultimately is the best dispute resolution process in this whole list of resolution processes. If the CPA is applicable, legal action through the normal courts may only occur after this process has been finalized and the outcome is still not to your satisfaction. If it's not applicable, then you can approach the court directly.
Okay, and now in closing, Isabella, do you have any tips for me and also for our listeners before we purchase a second-hand vehicle, apart from all the tips you just gave us?
Yeah, so the NCC have actually published this in a document with respect to what you should and should not look out for. And they've included 3 very important points when you purchase a second-hand vehicle. So firstly, disclosures and information. Obviously, the CPA recognizes the need to provide consumers with crucial information when they're buying a second-hand car so that they can make an informed decision. Cost price must also clearly show any additional fees, road fees, licensing fees, etc. And one must not be tempted to take the vehicle as a footstool or as is, but rather ask the dealer to inform you about all the defects so that you can make an informed decision. You have to specifically agree to accept the vehicle in a particular condition. If the selling dealer cannot provide loose items such as the spare key or make sure any of those spare items, you must make sure that a record is made on the delivery document so that they can't pretend it didn't happen at a later stage. The receipt that they issue must have the name and address of the supplier, their contact details, the date of the transaction, the description of the vehicle, as well as the total price, including applicable taxes and registration charges, if there are any, as well as the fact that you need to request information in plain and understandable language to be able to agree with all of the T's and C's attached to the transaction. Also, what's really important and what we really recommend is that you ask the dealership if the vehicle has its original engine and ensure that it has police clearance if the engine was changed. The second point that's really important is the contract terms. So here, a consumer must beware and confirm information provided with regard to the quality, the model, the performance, all of those. Contracts must not be such that the consumers find themselves unfairly and unjustly accepting obligations for something they would not ordinarily be obligated to do, or sometimes waive any liability of the supplier. Such T's and C's need to be expressly brought to the attention of the consumer even before they enter the contract. And consumers cannot be expected to contract out of their rights of the CPA. Read your contract thoroughly and avoid contracts that say that the vehicle is purchased as a footstool or as is or as scrap. These are all terms they use to try and confuse you, as it often happens with these second-hand agreements. Make sure that your offer to purchase is signed by all parties and keep all of your sales records and contracts at the end of the transaction, as they'll be needed in the event of a dispute. And lastly, safety and good quality, obviously, which is the main section of the CPA applying to you. In ensuring the safety, the Act requires that the products include secondhand vehicles available for sale must be of good quality, in good working order, and have no defects. The legislation further endorses the issues of safety by providing for a mandatory warranty of 6 months, which allows a consumer to return the product should it fail, as stated in Section 56. And a consumer has bought a second-hand vehicle that exhibits defects within that period, has the right, obviously, to return the vehicle to the dealership for repair or replacement or refund. The supplier is then expected at the discretion of the consumer to do either one of those things. You may insist on a current roadworthy certificate and inspect the service history. This will tell you a lot about the vehicle. Please have the vehicle independently inspected. Even if you have to pay for this, it's worth it. Any reputable dealer will sell the vehicle to the party of your choice. The inspection report should then be discussed with the selling dealer before you enter into the agreement. So it's really important that you remember to shop around, compare prices, and strictly deal with reputable car dealerships.
Isabella, I must congratulate you. That was thorough. That was in-depth. Thank you so much. I think, well done. For 15 minutes, that was a lot.
It's a lot of money you're spending on a car, hey?
Yeah. Yes, but I think you're going to save a lot of people a lot of heartache, because sometimes buying a second-hand car can just be buying a bottomless, well.
Yeah, no, and you never know what's happening behind the scenes. So rather stay, or as young people say, stay woke and make sure you know what you deserve and what rights are afforded to you, actually.
Exactly. Well, thank you so much, Isabella. That was great. It was nice to talk to you again. And remember, Hahn Hahn Attorneys can protect your rights. Don't hesitate to ask them anything on social media as well. Or you can email info@hahnlaw.co.za or call them on 012-431-2480 or 086 0995130. That was Associate Attorney Isabella Mazzone. Thank you so much.
Are you or your business in trouble and struggling to find a solution? Call Hahn Hahn Attorneys as we assist clients in finding solutions. We specialize in consumer and food law, commercial and construction law, forensic investigations, and administrative law. Visit hahnlaw.co.za. That's HAHN. We assist clients nationwide. Hahn Hahn Attorneys, because we care. Don't miss Legal Talk with Hahn Hahn Attorneys, Wednesday mornings at 10 on eRadio.